For admission, item number 1.
Your Lordship, this case was initially handled by Mrs. Mary, and it was recently endorsed to me. And I have found that we have received the parawise comments, and the affidavit opposition will be filed within this next week, Your Lordship.
Yes, you give us time. But Ms. Louis, learned counsel, learned government advocate, who submits that the parawise comments are ready and we will be accordingly filing the affidavit in the next week. In view of the above, a list after the ensuring invocation.
Much obliged, Your Lordship.
Item number 2.
Lordship, in last court date, I have sought time
Yes,
to obtain instruction whether settlement is going to be there or not, and to get some concrete instruction. Lordship, I have received some oral instruction, and that Lordship, at this stage, they've asked me, they have requested me to sought some more time.
who's the counsel for the petitioner?
Mr. Van Lenhaka, Lordship,
Does he have anything to say in this matter? He's not present. None appeared for the petitioner, while Mrs. Malswamy, learned government advocates, has prayed for further time. Since it appears that the parties are still attempting to come to some settlement. In view of the above, list after the ensuing vacations on a date to be fixed by the registry.
deeply obliged.
Item 3.
May I please, Your Lordship? My lord, the case is about the non-inclusion of the petitioner's land from the 3G notification dated 13/8/2021, my lord. As I've stated in my petition, my land is damaged. The construction of NH6 has passed through my land, but somehow I was not included in the said award. And I have annexed a photocopy of the damaged land in my petition. If I take Your Lordship to page 38 of my petition, my lord.
Yes, so in this case, the CGC is present.
Yes, my lord.
Last court date, the matter was adjourned since the CGC was absent, and previous to that, it was noted that the CGC was to file their counter affidavit. So anything to mention in this matter? CGC?
My lord, we may not be a necessary part in this case.
Okay, because it appears on the quick perusal of the writ petition that the prayer made in the instant writ petition is limited
Yes, my lord.
to the prayer that the spot verification should be done in the instant case, isn't it?
Yes, my lord.
To verify whether the said road is passing through the landed property of the petitioner, and if so, adequate compensation for the what? For the land
Land.
for the destruction.
Yes,
Is it
destruction and
damage
land.
for the damage of the land?
Yes.
Is that your? Let's see your prayer portion. If it is that limited prayer, then we can dispose
Yes,
of,
my lord.
isn't it?
If I may, my lord.
Uh,
If
so your submission is that the road is not constructed within the land, but it is a little bit afar off, isn't it? So
if I may kindly
yes,
direct
yes.
your lordship to Annexure 1, page 7
Annexure 1, page 7.
of the affidavit in opposition filed by the respondent number 2 and 3, my lord.
Yes.
The second point, my lord. If I may read, my lord. Page 7, Annexure 1.
Just a sec. So your submission is that verification has already been done? Anyways,
If I may read, my
Yes,
lord, point number 2. A joint inspection was conducted with EPC contractor, AES representative, and EPC contractor, MS Balaji representative, attended the inspection. VCP Chungte was present during discussion after inspection. Based on joint inspection and discussion, the findings are as under. A. The plot of the said owner is 1,500 meters away of alignment, my lord. And all road work execution is constrained within provided ROW, which is right of way, my lord. Now it is our submission that the plot of the petitioner's land, my lord, is 1,500 meters away from the alignment. Now he is saying that because of the construction work, his land has been damaged. Now we are saying it's 1,500 meters away, my lord. Now there seems to be a disputed question of facts, my lord. Now whether a writ court, in case of disputed question of facts, can entertain the petition, because evidence would have to be taken, my lord.
so his limited prayer, okay, is that a spot verification be done. Isn't it?
Yes, my lord,
Let
but
us
what our
spot-
submission is, we have already made the spot
But
verification.
without his being present, isn't it? Who was he present there?
No, my lord. In fact, my lord, the respondents' engineers, they are all non-mesos, my lord. It is also doubtful whether they can read the vernacular description of boundaries also, my lord. And also, they said
So
that
here, your joint inspection,
yes,
this was before.
no, this was after filing, subsequent to filing of this petition.
Okay,
And the
after filing your writ petition, a
Yes.
spot verification was done.
No,
Is it?
the respondents themselves have conducted
Okay.
by their own team,
After.
forming their own team, yes, my lord. I was not included and the Kala was also not included. Kala is the appropriate authority in this matter, my lord.
So this was done after the writ petition was filed.
It was done on 1/4/2024, my lord, as per the letter.
And
Yes.
if I take your lordship to page
Now, whether
38
his
of my petition.
presence will alter any difference in the
So
verification
let
conducted.
all the parties concerned be involved in the spot verification.
Yes, my
Isn't it? And thereafter we will see remanding it back to the lower court also. Again, the same thing, spot verification has to be conducted, isn't it?
Evidence
And
will have to be
this was
taken.
done. This was done after the writ petition was filed.
So his prayer was for verification, and verification was done accordingly,
But-
which states
but
that his land has not been
His
damaged.
prayer for verification is when he may also be included as a party
Yes,
at the time of the verification. You have gone and done it behind his back quietly, isn't it, before filing? So, since it is done after the writ petition has been filed, and he was prayed that he may also be present when the verification is done, so we can dispose it of, you all go together. What is the problem in that?
We do not have a problem, but my submission, my lord, is that he's saying his land was damaged by us. We are
And you are
saying his
saying
land
it's
is
not.
far away. Now the
So
disputed
you
question
all
of facts
conduct
arise. my
So
lord.
you all conduct a spot verification and resolve the problem. Why keep the matter dragging?
Yes, my lord.
Isn't it? Why keep the matter dragging when you are saying it's not and he's saying it is? And he prayed that a spot verification be done. So let it be done and you find out what is correct or isn't it? Because after he filed his writ petition, where he is praying that a spot verification be done, where he is also a party, you have gone ahead and done a spot verification in his absence, and then filed your counter affidavit. So let a spot verification be done with all the concerned parties, and then you can always take your same stand and see. Let him also go and see whether it is how much, 1,500, is it?
Yes, Your Lordship.
Kilometers away. You can all solve this on one day when you all go together, isn't it? Now we'll have to see who are the parties. It is the parties in the writ petition
Yes, my lord.
who are to be involved in at the time of the spot verification. So let us see the parties that are involved. You have the Union of India, then you have the Deputy Commissioner along with the petitioner. Isn't it? So it's a simple matter. Heard, Mr.
Nalbiak no namte, my lord.
Lalbiak Nunga Namte, Learned Counsel for the petitioner, along with Mr. Samuel L. Samke, Learned Counsel for respondents number 2
2 and 3.
2 and 3, my lord.
and Mrs. Zairam Sangpui, Learned CGC for respondent number 1. The Learned CGC submits that they will not be filing any counter affidavit since they have nothing to say in the instant matter. The Learned Counsel for the petitioner submits that the instant writ petition is filed due to the construction of road by the respondents number 2 and 3. Within his landed property covered by periodic patta number 307702/09/321 of 2000, located at Chungte village area, Champai district. Full stop. He submits that he had utilized his landed property for wet rice cultivation and for seasonal crops. Which is the main source of income for him and his family. Full stop. The petitioners on 21/05/21 issued a notification dated 17/05/2021 under Section 3, capital C of the National Highways Act 1956, inviting objections in connection with the acquisition of land for development of NH6 stretch 130 kilometer to 147.25 kilometer, at Chungte village, Full stop. Okay. Thereafter, on 13/08/2021, notification of award under Section 3G and 3H of the National Highway Act was issued, was published, okay, was published by respondent number 4. However, the instant petitioner was excluded in the said award dated 13/08/2021. Aggrieved by this, the petitioner had approached the respondent number 4 on many occasions and submitted his complaint, which remained ineffective. The learned counsel for the petitioner submits that though he was informed by the respondents that the construction slash development slash widening of the NH6 did not affect his landed property as per the proposed alignment. However, around 1500 meter within brackets approximate of the landed property of the petitioner was cut through by the respondent for the construction of the said NH6. The learned counsel for the petitioner submits that the instant writ petition is limited to the prayer that the respondent authorities should conduct a spot verification of the petitioner's landed property and verify whether the landed property of the petitioner was encroached upon, and if so, proper acquisition and payment of necessary compensation may be given to him. Mr. Samuel L. Sangte, learned counsel for respondent number 2 and 3, on the other hand, submits that the respondents had already conducted a spot verification on
1/4/2024, Madam, as per the letter.
on 01/04/2024. Full stop. In the joint inspection conducted with the EPC contractor, AE's representative and the EPC contractor MS Balaji representative attended the inspection. Full stop. VCP Chumte was also present during discussion after inspection. So he was not there during the inspection, after the inspection. Okay, full stop. Based on the joint inspection and discussions, it was found that the plot of land owned by the petitioner was 1500 meters, is it MTR?
Yes,
Meters
Your Lordship.
away of the alignment. And all road work execution is constrained within the provided ROW. So, the learned counsel for the respondents thus submits that since this is the report of the spot verification conducted, there appear to be a dispute on the question of facts and that this matter should be remanded to the lower court for proper adjudication by adducing necessary evidence.
Yes, my lord. And if your lordship allow me to provide one citation, my lord, with regards to disputed question of facts.
Okay. The learned counsel, in support of his submission, has
2020.
relied on. Give.
2021-10 SCC 690.
Union of the decision of the Apex Court and Union of India and others versus Pune Hinda, reported in 2021, 10 SCC 690, para.
24, my lord.
What does it say, para 24?
If I may read, my lord.
Yes.
Therefore, the dispute could not be raised by way of a writ petition on the disputed question of fact. Though the jurisdiction of the High Court is wide, but in respect of pure contractual matters in the field of private law, having no statutory flavor, are better educated upon by the forum agreed to by the parties. The dispute whether whether the amount is payable or not, and or how much amount is payable, are disputed question of facts. There is no admission on the part of the appellants to infer that the amount stands crystallized. Therefore, in the absence of acceptance of joint survey report by the competent authority, no right would accrue to the writ petitioner, only because measurements cannot be undertaken after passage of time. Maybe the resurvey cannot take place, but the measurement books of the work executed from time to time would form a reasonable basis for assessing the amount due and payable to the writ petitioner. But such process could be undertaken only by the agreed forum, that is arbitration, and not by the writ court, and it does not have the expertise in respect of measurements or constructions of roads. This is basically on the maintainability of the writ petition, my lord, since there's a disputed question of facts, my lord.
Having heard the submissions made by the learned counsels for both the parties, this court, considering the nature of the limited prayer made by the learned counsel for the petitioner, finds it appropriate to dispose of the instant writ petition with a direction that a spot verification of the landed property of the petitioner is to be conducted in the presence of the petitioner and representatives of respondents and representatives of all the respondents. Okay. And thereby to verify whether the construction of the road, where is it? Within the construction of the road for development of N86 stretch 130 kilometers to 147.25 kilometer in the village of Chungte, Champhai district, encroaches upon the landed property of the petitioner or not. This court has observed that the said verification report was conducted after the filing of the instant writ petition, and therefore it is appropriate that the writ petitioner was also made a party at the time of the said verification done on that date, so and so. In view of the above,
If I may interrupt you, Lordship.
yes.
Respondent number 4 may be directed to convene the spot verification because they are the competent authority for land acquisition, my lord.
Was the respondent number 4 present when the,
No, no.
okay. This court also finds that it would be appropriate if the respondent number 4 took the steps for convening a date for conducting of the spot verification, since the respondent number 4 being the deputy commissioner slash what?
Competent authority for land acquisition.
Okay, being the competent authority, being the deputy commissioner is the competent authority for land acquisition. These necessary steps is to be taken within time,
A month's time, maybe.
within, now festival is 4 weeks,
Within 4 weeks, madam.
within 4 weeks from the date of receiving a certified copy of this order by the concerned parties. Thereafter, after the spot verification is conducted, if it is found that the landed property of the petitioner is encroached upon, steps is to be taken by the respondents for paying the appropriate steps is to be taken by the respondents as per law for compensation to the petitioner. Accordingly, the incident with petition number 8 of 2024 stands disposed of as above. Now,
Deeply
the
obliged,
reason why I had passed this order is because it is after the writ petition is filed, he's also, you're already a party, he's also already a party. Okay, in between that, you had gone and made the writ petition switch. He should have been included, and all the parties also.
There was no specific direction
No
as when the
specific-
inspection
there
was conducted.
no
madam.
specific direction, but the spot verification was done only after the writ petition was filed.
Now, since in light of the
So I will also reflect how the judgment cited upon is not applicable in this case.
it was on the
later.
maintainability matter because of the disputed question of facts, since they had conducted the survey.
Anyways, so you have
I'm just saying,
cited,
Madam.
you have cited the authority. I will just reflect it after reading this thing as to why it cannot be applied in
Yes,
case.
Madam.
That I'll mention.
Yes, Your Lordship.
Deeply obliged, madam.
Item 5.
Praise your lordship. Lordship, this is a very simple application for releasing a seized
Yes.
vehicle.
Your Lordship, I'm appearing on behalf of my senior who is out of station due to prior commitment.
So you talked to your senior.
Yes,
This
we
is-
have, I have received an instruction.
Ah.
So we will be having an affidavit in this matter. So if your Lordship.
You're going
in
to
this-
object? is
Yes.
it?
So we will be
Lordship,
having for that.
objection is already filed by the DRA. It is in the
Is
record.
it?
Yes.
Have you already filed your written
As far as to
objection?
my knowledge, Your Lordship, I don't think we have filed for any
Where is it?
DRA has
written?
already filed.
Where? It's not in the file?
It is in the record, Your Lordship. Earlier in the first court date, this honorable court is directed to submit the objection
So
by the
have
DRA.
they filed?
Yes, they have filed. After filing that objection, only case was listed, Your Lordship. These are directed there in the first order, Your Lordship. The first order. it was
First
direct-
order,
After getting only objection from them.
no
only-
written objection. No written objection. Isn't it? You have a copy of the written objection?
No, Your Lordship,
Then?
I have not served.
If you don't have, it should be served to you also.
No, Your Lordship, if Your Lordship see the first order of this
What
honorable
is the
court,
first order?
first order
what?
of this honorable court.
Call for the report relating to the vehicle registration bearing so-and-so, seized
Yes.
in connection with so-and-so. So has the report come?
Report has come, then case was listed, Your Lordship.
So
nothing, they have to say nothing
then
now.
list the matter after 1 week.
Yes. Then again, this is the third adjournment, Your Lordship. It's a very simple application, Your Lordship can make because she is representing the very
so-
simple
Your Lordship,
application, Your
if
Lordship.
I
And 6
may-
months, it is already expired 6 months. They have not completed the
Okay,
investigation.
positively by the next date, you file your written objection and will make, an attempt will be made to dispose of the said criminal petition in the next date. We'll pass that and then let's see, isn't it? Is it a perishable good? No, what you're praying,
No.
isn't it? Yeah, so let it be. Heard Mr. N.H. Bar Bhuiyan, Learned Counsel for the petitioner. Also heard Miss
H. Balaramvati.
Vanlal Rimroti, Vanlal Rimroti, Learned Counsel, appearing on behalf of her senior Mr.
Johnny L. Tocho.
Jonathan L. Tauchong. The Learned Counsel, appearing on behalf of Mr. So-and-so, submits that the Learned Counsel submits that Mr. Johnny L. Tauchong is not able to appear. What?
He has prior professional commitment. He's in Bangkok presenting his doctorate paper.
How long? Is
Your
he going to
Lordship,
be in
his leave
Bangkok?
application was still reflecting on the cause list.
Okay, has,
Today is the last day of his.
is out of station and he has accordingly also submitted his leave application. It is also submitted that the respondents will be filing their written objection. First off, in view of the above, this court find it fit to adjourn the matter for
If
3
possi-
weeks.
Yes.
Next Monday.
List the matter on,
Next Monday, 9.
Your Lordship, senior will not be will be unavailable till the 10th of this month.
so after the vacation, when? On,
Yes, after the vacation will
list
be.
the
Lordship,
matter on.
Lordship, if it is after vacation, it will be injustice with me, Your Lordship. Because Your Lordship, this is my vehicle is a new vehicle. It is detained in open space. They have no space, parking space also. These people that I have mentioned in my read petition. So Your
But,
Lordship
Your
may
Lordship,
take
this is
after
still
10
an
also.
ongoing case.
After 11 also, you can be fixed, Your Lordship. Otherwise, because this is my finance vehicle I have
List
purchased.
the matter on, let's make it on 14th.
No problem.
On 14th,
14.
2025. In the meantime, the Learned Counsel for the respondent is to file their written objection positively and an attempt will be made to dispose of the writ petition in the next date of listing. Yes.
Right.
Item 6.
Your Lordship, now this case is a covered matter. Since all the other analogous matter had already been disposed of by this honorable court via the order dated 21/11/2024 in a common judgment.
Yes. Who is the counsel for the respondent? What is the writ petition about?
It's about, there is a construction of Tipa Laki Lope Lopu Road. In short, it is TLL.
Construction of Tipa Laki
Lope
Opel
Lopu
Lopu Road. Okay.
TLLL.
Yes.
Yes. So
What is the
Even
correct
though the-
pronunciation? Anyways,
this honorable court via the
So this is the construction of
yes. So
TLLL Road. Then
So, this honorable court in a common judgment and order dated 15/11/2024 in WPC 20 of 24, 2014 and 30 of 2004 had passed that held that the Mizoram Land Acquisition Rehabilitation Resettlement Act 2016 is made inapplicable. But even though it is held inapplicable, they are proceed under the Mizoram Land Acquisition Act 2016. So now the case, what we made a prayer is to go as per the Central Act, right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act
So at the time
2013.
of acquisition of your landed property, the 2016 Act was used, is it?
Inapplicable, already held inapplicable by this honorable court.
It was held inapplicable, but in spite of that, 2016 Act was
Used,
isn't
yes,
it? Huh?
yes.
So you're saying that 2016 Act was used, but since it has been held inapplicable, you're praying that the 2013 Act should be used.
Yes,
It's
yes.
as simple as that?
Yes, yes.
So was the award made, where's the award?
Annex,
How was it used? Where's the award using 2016?
it's page number 42, Annex 3. And
Okay, this
the
award
notification-
was made under the 2016, is that
yes,
it?
yes, yes. And the notification is at page 40 also. It's clearly written that the Mizoram Land Acquisition and Rehabilitation and Resettlement Act.
So did you receive any amount?
Pardon?
Have you received any amount?
Yes, yes, I have already received amount, but some solicium, some person also solicium says land value is taken in contradiction with 2013.
So now you want that the balance amount.
Yes, yes.
So come, give me your case, huh? So now you are saying that, so give me the facts of the case properly.
Yes.
How much have you received? As per the award, you have received the whole full amount? When did you receive the full amount?
We have received in the year 2023 only.
In the year
Since the final
2023?
award was the final notification and declaration under Section 11 of the said Act was pronounced only on 14/01/2022. And the award was prepared in the on 25/01/2023.
Award was prepared and you received the full amount?
Yes, yes, we received the full amount, but
When did you receive?
I don't know exactly the when we received the, but it's in the year 2023.
Okay. So now on the application of the 2013 Act, what remains to be done?
See, since the Mizoram Land Acquisition Act 2016 was held inapplicable and it was the said judgment was upheld by.
Yes, that we know.
Yes.
So so what remains to be done in your case?
So to go as per the
So
2013
yes,
Act,
so
Central Act.
so what remains to be done in your case? You have received certain amount. So on applying the 2013 case,
Yes.
what steps are to be taken?
So to give the statutory benefit as rehabilitation and
Yes.
resettlement and benefit under 2013 Act.
What are those?
100% solicium.
Okay, so you were given how much percent solicium previously?
It's different based on the land pass. Sometimes it is
So how much
10%.
percent? Okay,
10%, sometimes it is 20, 30, 40, 50% was deducted as in the as a Solasium. From the Solasium.
No.
See, if I might take your lordship to page,
In the 2016 Act,
yes,
what is the percentage for Solosium?
it is different as per the
How can it be different?
land pass.
I'm not asking the amount, I'm asking the interest.
Yes, it's 10%, 30%, 20%.
Is it?
Yes, it's different as per the land pass. If I may take a look at page 34, it's very clear from, that is the award. Under column number 11,
Oh,
yes, the Solasium deduction rate was written there.
you don't reduce Solosium, you add. So from your award, it has to be reduced, 100% reduced.
No,
Then you will get very less.
They were not given the 100% Solasium. So
How much Solosium were they given?
the petitioner, it's different from each petitioner. See, in some petitioner, Solasium was deducted
Okay.
10%. In some petitioner, it is 20%.
20 and 10.
30 and 50 also, 50% also.
So you're saying that all of them should be given 100%
Yeah, it should be
Solosium.
given, what my prayer is that they should be given 100% Solasium.
Oh, what else?
So the illegal deduction of the cess amount should also be returned. That's my.
Where's the cess amount deducted where? How much percent of the cess amount?
10%.
Okay. 100% Solosium, 10% of the cess amount deducted.
Yes.
Then what else?
And also, we have also pay for the giving the correct market value of the land.
Maybe evaluation.
Valuation.
But evaluation was done in 2023.
Yes.
So you're saying that the landed property was not correctly evaluated?
Yes.
It was evaluated at what rate?
Which different.
What's wrong with the market value?
It was
Per square feet?
per square feet. Sometime it was 24 and 28.
So what,
It is,
according to you,
they
what is the
undervalued,
correct?
my
So
land.
according to you, what is the correct value? On what grounds have you prayed for the re-evaluation of your landed property?
As my correct land value was per square feet is more than rupees 60 per square feet.
On what basis? You're saying that it is less and it should be evaluated at rupees 60 per square feet. On what basis? You're reading and
The
saying,
state, my lord, the state award number 10 of 2022 was passed solely based on the past land acquisition proceeding. So
see, I can just understand the 100% and the 10% says. Now you're unhappy with the land value
Yes, yes.
evaluation of the land. On what grounds? What is the market You're going to compare with what? What?
See, if I may take your lordship to the page 43.
43.
Yes, this is the reason why they made get value of the land,
Market value.
Yes, under para 4.
Oh.
Yeah.
So what's wrong with this?
Merit, this one. Market value of the land has been determined in line with the compensation already paid via award number 1 of 2013. Award number 1 additional 1 of 2018 along the same stretch of the road 40 to 57 kilometer of Tipa, Laki, Lupe, Lupu Road, and award number 6 and 7 of 2021 along the stretch of Zongling Moshe Chapi Road, 38 kilometers. So, my land value was determined solely on the basis of the past land acquisition award. So,
Okay.
which was
so
way
you're
back in
challenging
sometimes
43.
toward
Oh.
2013. Well, the award in respect of the present case was done only in 2023.
Okay.
So, since
Those 3 points. Yes.
since all the other analogous matter had already been disposed by this honorable court, then the same may be applied to my case also. Then.
But not regarding the land evaluation. What do you have to pray concerning the land evaluation? What did the court say? I'm asking because recently we have passed an order that it should be placed before the what reference court, is it? Or what? What are you praying?
My prayer is at the page, the relevant portion is at page 36.
No, what you have submitted by citing the decided cases of this court
Yes.
concerning re-evaluation. Was it done in the other cases?
Yes, my lord.
Let's see the relevant para. You have cited WPC 125/2021.
Under para 8, at page 36.
Oh,
Yes.
I have to extract your submissions because you just want to run away saying it's covered, finished. But I want you to do your homework. Page?
36.
Just a sec, page 36. Para?
If I may read from para 7, 8.
7.
Yes,
Okay.
8 also. Yes.
Yes.
Oh, may I start from the para 8? Thus, upon the perusal of the material available on record and upon hearing the land council for the rival parties, the petitions are disposed of with the following direction. The petitioners shall, within a period of 3 weeks, submit their respective application before the district collector, Siaha, giving all details of their land which was acquired for the aforementioned purpose, while also specifying the amount that they have already received. The petitioner may also indicate why the amount awarded is not applicable to them by giving reason other than non-application of the 2013 Act, the Act of 2013. The district collector, upon receipt of such application, shall undertake the exercise of reassessment of the compensation amount to be received by each of the land owners of the acquisition of their land by applying the provision of the Act of 2013, inclusive of solatium and interest, and also interest on delay payment entitled to each of the landowner. The amount already received by the petitioner as compensation shall be deducted from the assessment and compensation so made. Such an exercise shall be undertaken by the collector as expeditiously as possible and at any rate within the outer limit of 3 months from the date of receipt of the application to be submitted by the petitioner. And 3, the collector, after passing the assessment as per the Act of 2013, shall then obtain the approval of the competent authority in the state government if required, and thereafter forward the same to the respondent Union of India representative.
Okay, so basically, concerning your prayer for re-evaluation, you're saying that it should be, that you may be allowed to make a representation before the district collector.
Yes, yes.
I think that's, isn't it?
Yes.
So for the re-evaluation, you're saying that you will make a representation before the district collector.
Yes,
As simple as that, isn't it?
yes.
Ah, yes.
It's covered matter. However, regarding redetermination of the land value.
Re-evaluation, yes.
Should be as per the court order, the petitioner should approach the district collector.
With their submissions and their
Yes.
grievance, isn't it?
Yes.
It is not for this court to decide how much the money should be. Isn't it? Yes. Okay, I'll pass the order
Yes, madam.
accordingly, being a covered matter.
Yes, madam.
Very obliged.
Obliged.
Item 7.
Yes.
May it please your lordship?
Oh,
Our case is that we are the regularized employee of the Aizawl Municipal Corporation, my lord, governed by the Mizoram Municipalities Swiss Rules of 2019. Our case is that on 4/10/2022, which is at Annexure 9, page number 28,
yes.
office order was issued by the respondents wherein 4 personnel of the Aizawl Municipal Corporation were transferred and posted to the Lunglei Municipal Council. However, the said office order was cancelled and a new office order dated November 3rd, 2022 was issued at page number 30. If I may read. Office order dated 3rd November 2022. Whereas the government has established Lunglei Municipal Council and it is necessary to post staff for functioning of the said council, and whereas no recruitments has been done for the council, it is found expedient and necessary to temporarily attach staff from Aizawl Municipal Corporation. Therefore, in exercise of Rule 24 of the Mizoram Subordinate Service Rules of 2019, the government is pleased to relax sub-Rule 2 of Rule 4 of the said rules. The Municipal Commissioner AMC is hereby requested to issue order for temporary attachment of the following staff to Lunglei Municipal Council: Junior Engineer 1 number, UDC 1 number, LDC 1 number, Driver 2 numbers. Further, the government is pleased to revoke Department's Office Order so-and-so dated 4/10/2022. This issue with the approval of the Honorable Deputy Chief Minister on 3/11/2022. Thereafter, my lord, at page number 31, the respondent issued office order wherein 5 personnel of the Aizawl Municipal Corporation, 5 staffs were temporarily attached to the Lunglei Municipal Council with immediate effect. These personnel were at Lunglei Municipal Council since this office order was issued. Thereafter, on 15/1/2024, the said staff submitted their representation, which is the type copies at page number 33, my lord, asking for the repatriation. That is the vernacular, and the true English translation is at page number 34. Asking for the repatriation back to the Aizawl Municipal Corporation. In pursuance to their representation, the respondents issued of the impugned office order wherein the 5 staff that I've just mentioned were repatriated, and in their stead, we, the petitioners, were temporarily attached to the Lunglei Municipal Council and were directed to join the place before 15 July 2024. Aggrieved, we submitted our representation, our legal notice through our previous council. However, it bore no fruit till date. And what I would like to have your lordship attention is at page number 48, annexion number 18, my lord. This is the Mizoram Municipal Subordinate Service Rules of 2019, which governs our service, my lord. So at page number 49, this page number 49 contains the sub-rule 2, rule 4, which the respondents have relaxed. If I may read. Rule 4, sub-rule 2. Members of the Mizoram Municipal Subordinate Service shall remain under the direction and control of the respective municipality to which he is recruited and shall not be liable to be transferred to other municipality. This, however, if I may have your lordship to page number 53.
Where's the relaxing
Yes,
provision?
it is page number 53, my lord. This is the relaxation clause, rule number 24, power to relax. Where the governor is of the opinion that it is necessary or expedient to do so, he may, by order and for reason to be recorded in writing, relax any provisions of these rules with respect to any class or category of persons. However, my lord, in the meantime, we also submitted an online RTI which was received. The RTI was with respect to the note sheet on which the transfer was made. It is at page number 37. This is the annexure 14. The type copy is at annexure 14A, page 39. Perusing the note sheet, it can be seen that no approval from the governor was obtained, no order was issued, nor reasons for the invocation of the relaxation clause has been reflected or recorded in writing, my lord. Hence, these impugn office order dated 4/7/2024 cannot be sustained. And once again, I would like to have your lordship attention back at page number 30, annexure 10. Therein, it is seen on the last paragraph that these issues with the approval of the Honorable Deputy Chief Minister on 3/11/2022.
Not the approval of the governor.
Yes, where the approval of the His Excellency the Governor is required, my lord. So all these office order, impugn order, was issued in contradiction and in violation of the rules set by the AMC themselves, my lord. Hence, we come before your honorable court praying for the cancellation of the impugn office order dated 4/7/2024, my lord.
Where's the 4/7/2024?
It is at,
Because you have taken me to the order 3rd November 2022.
yes, it is at page 41, annexure 15, my lord. This is the impugn office order 4/7/2024, wherein 5 staff who had been previously temporarily attached at the Lunglei Municipal Council were repatriated, and in their stead, we, the petitioners, were again sent to the Lunglei Municipal Council.
So you are placed at serial number?
1,
the
2, and
order-
3.
Okay. So previously you were temporarily attached by the order 03 November 2022, is it?
03/10.
Annexure 10.
Yes, 03/10/2022, 03/11/2022, my lord, is for the order for sending staff from Aizawl Municipal Corporation. So in
But your
pursuance,
specific names have not been mentioned. here.
mentioned, my lord, it has been at page number 31, my lord. In pursuance to the order dated 3/11/2022, the respondents sent 5 staff from the Aizon Municipal Corporation.
Where did you read that line from? In pursuance?
There is no, my lord,
But then, so in the order 7 July 2024,
yes,
it says that in the interest of the public
yes.
and as decided in a executive council, meeting of the executive council held on 13/3/2024, where's that?
15/3/2022.
15/3/2024.
I
You
have
not-
no copy of that, my lord.
So your presumption is that this order
Yes, my lord.
047/2024 was in pursuance to the order dated 03/11/2023. But in the order, impugned order 047/2024, it says that it was as decided by a meeting of the executive council.
Yes. As
So where's this meeting? You don't have the copy of the executive council. Then what is the power of the executive council? Do they have the power?
As far as my situation is concerned, my lord, these relaxation of the clause for transferring of staffs from one municipality to another municipality has to be invoked as per the rules set by notified in the official gazette, my lord. So all these orders or all these rules have not been followed by the respondents, and as such we are aggrieved that our right has been violated, a statutory right has been also violated for not following those rules, my lord.
No,
Ab
but
initio.
in the rules,
Yes.
in the rules, in your mentioned rules, is there any mention of the executive council? What is the power of the executive council? Because you're saying the impugned order dated 04 July 2024 is in pursuance of the order dated your annexure 10, okay, 03/11/2022. But on reading of the impugned order, it does not mention the order dated 03/11/2022, but says that it is because it was decided by a meeting of the executive council held on 13/03/2024. So we want to see whether the executive council has the power to issue such an order, which you say is wrong, isn't it?
Yes, my
I
lord.
think we have to go on those lines,
Yes.
besides what you have mentioned.
However, if I may have your lordship to annexure number 18, page number 48.
18.
Yes. This is the Mizoram Municipal Subordinate Service Rules of 2019. To the best of my knowledge, there is no power given to the executive.
Okay, so you're saying that this order is not, is liable to be set aside because the executive council does not have the power to decide this, okay, and that they should be governed by the said rules. Is
Yes,
it?
my lord.
Okay, fine. Anything?
My lord, the petitioners have not challenged the parent order, annexure 10, page 30. In their petition. This is the parent order whereby the subsequent order was issued. So without challenging the parent order, the subsequent order, all those at the side,
You're saying that
Will still create a
annexure
problem.
10 is the parent order.
yes, this is, this is a direction made by the Secretary to the Government of Mizoram, UDNPA, directing the municipal commissioner to issue an order for temporary attachment of the following staff to Lunglei Municipal Council. Number 1, junior engineer 1 number, 2 UDC 1 number, 3 LDC 1 number, driver 2 numbers. So this is the parent order. We are only
Where's the
following.
meeting of the executive council held on? You see, the order that is challenged is 4th July
Yes.
2024.
Yes,
Okay? Now,
yes,
if you
madam.
read the order 4th July 2024,
Yes,
it says that in the interest of the public service and decided in a meeting of the executive.
Yes.
So we have to look at the minutes of the executive council meeting.
I don't have the minutes, my lord.
Produce that,
We can produce it. But, my lord, as we all know,
whether the minutes of the
Yes.
executive council has reflected the order dated, which you say is the parent.
yes, although reflected on,
Annexure 10.
my lord, as we all know, the UDNPA is the controlling department of the AMC. So even all these orders are set aside, we will still have to follow this order if it is not set aside. So they have to challenge this order.
What do you have to say in rebuttal?
With respect to the submissions made by my learned friend, my lord, his submission is not included in his affidavit.
Whether it is included or
Well,
not, it is the law, my lord.
but be that as it may, we are aggrieved is pertaining to only our temporary attachment, my lord, not the parent order. They can always do something else with the parent order, but not with us,
Okay,
my lord.
so you are not aggrieved.
We are not challenging the parent order because, my lord, we are, our our grievances pertains to only our transference order, my lord. With the parent order, the respondents
Now,
can transfer.
if you look at the
anybody else.
documents, I think it is mentioned somewhere that they have been sent back to Aizawl, anything like that?
That is for the previous staff that had been,
Previous stuff.
yes, repatriated.
Now, what about the service rules?
Yes, my lord.
4 of 2. What about the service? You're saying that it is not in consonance with the service rules. So the respondents, what do you have to say about this?
My lord,
4-2.
yes. With regard to that submission, my lord, the approval of the governor is required as per the rules. But nevertheless, what I have submitted, my lord, because now they are challenging that some people are repatriated back and they've been sent. If their order is set aside, we will have to send another person because this order will still stand. And those person will come again. Unless and until this order is set aside, it will not fix anything, my lord.
Names have not been mentioned.
Yes, names have not been mentioned. Even though,
So maybe you should challenge this
Yes.
because you have also mentioned that this order itself is wrong because it is issued with the approval of the Deputy Chief Minister. The Annexure 10.
If I may be allowed to amend my,
Yes, okay. Because here it's not been listed for hearing. Okay. Then you could have a case because the rules also clearly state that. But if that order, as mentioned, is not challenged, then someone else will be transferred based on that order.
it will still create a problem.
But Ms. Valentina, so-and-so, learned counsel for the petitioner, along with Mr. Zoram Chana, learned counsel for the respondent. Standing counsel, is it?
Yes, my lord.
Standing counsel for the respondent's
Number 3.
No, respondent number 3. Yes, the government counsel is also here. Anything to government advocate? You're also a party? Along with Mrs. Mary El Kiante, learned government advocate for the state respondents. After hearing the learned counsels for both the parties, the learned counsel for the petitioner prayed that she may be allowed to you withdraw and file afresh. Instead of adding that little thing, it will be a bit troublesome. Okay, we'll be allowed to withdraw the instant petition with a permission to file afresh, if so advised. Praise the Lord. With petition number 80 of 2024. stands disposed of on withdrawal with a permission to file afresh. Yes. Obliged.
Obliged, my lord.
For order, item number 8.
May it please the Lords. Lords, I appear for the respondents. There is an application seeking condemnation of delay of 1396 days. Now, before my learned friend starts, my Lords, we have an objection with regard to the maintainability of the present proceedings, the way they have been filed before this honorable court at this stage.
So,
Well, if my Lords permit, I can begin.
this is the IA for,
Well, is the IA is for condoning the delay of
And the delay of
1300
1096 days, Your Lordship.
What we say is, my lords, that your lordships had originally granted the petitioner's leave. If I may draw your lordship's attention to the memo of appeal at page 20
page 20.
of the memo of appeal. What had happened is, my lords, originally a 482 application had been filed, and that came up for disposal before this honorable court, which was disposed of by judgment in order dated 13/12/2022. And my lords, I'll draw your lordships to page 20, the operative portion at para 17.
Para 17 of the judgment, is it?
My lords.
What? Are we on the same page? Let me see. Criminal appeal, in the criminal appeal,
Well, it's the copy that I have before me. It is annexure 4.
annexure 4.
The last page of the appeal, Your Lordship.
Is it annexed to the thing also? Show me.
Annexure 4, okay, annexure 4,
Paragraph
para
Page
17.
20, my lords. Paragraph 17.
17.
Well, it's 1/7.
Oh,
My lords have it.
yes.
Well, it's for the above said reasons, the criminal petition under section 482 CRPC is dismissed with the liberty to the petitioner to approach this court under section 378(4) of CRPC by way of an appeal, if so advised.
So
Now,
now how
thereafter-
have they approached this court? Yes.
Now they have come before your lordships under, my lords, with an appeal. Now, as your lordships are aware, if I may draw your lordships' attention to the CRPC. Section 378.
Now let's see under what section have they approached this court in the appeal. Let me just have a look at that.
My lords. It is under 378(4).
Yes.
Now, well, it's the requirement of law under 378(4) when an appeal is filed is there has to be an application seeking special leave under 378(5).
Okay, let's see the
If my lord, kindly have the CRPC, please.
$378.
5. I'll take your lordships both through 378(4) and 378(5).
Yes. Yes, please go ahead.
Well, it's, if such an order of acquittal is passed in any case instituted upon a complaint and the High Court on an application made to it by the complainant in this behalf grants special leave to appeal from the order of acquittal, the complainant may present such an appeal to the High Court. So what is, my lords, mandatory is that prior to an appeal, an application seeking leave to appeal or special leave to appeal has to be preferred before this honorable court.
Special leave is prayed for, notice is issued, and then maybe a hearing is done on the
On
prayer for-
application seeking special
Yes.
leave, my lords.
That a hearing has to be conducted. If it is surrounded, then the appeal is filed, isn't it?
Absolutely. And my lords, may kindly also have a look at subsection 5.
Yes.
There also there is a difficulty. No application under subsection 4 for the grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months where the complainant is a public servant and 60 days in every other case computed from the date of order of acquittal. So there is again a period of limitation that has been prescribed under subsection 5, my lords.
That whatever, if the application is made and
Hello,
the.
that
it's
would come
done,
only
then
when
it
an
will be-
application is
That will hear in the condonation, they'll pray for the condonation of this when it's
Absolutely.
possible. But the first provision, you'll have to file an application, we'll have a short hearing on that. If we allow that, then that's the steps that should be taken. Special leave should be, isn't it?
So, my lords, as on today, this appeal, my lords, and the application seeking condonation of delay in my submission would not be maintainable.
Your Lordship,
Yes, because after the provision made under 4, okay, subsection 4 is complete, then if there is a delay, if there is some delay,
Yes.
then it's not within 6 months or whatever, the period which is prescribed, then you will have to apply for a condonation of, make an application for condonation of delay.
yeah,
after
for
the
instance,
completing
the
the
instant
first step.
continuation of delay, yes. I have filed for it, yes. And
So, well, what do you have to say?
the reason for the condonation of the delay is that, like in the previous, like a learned friend already said, there
No,
has been.
but what you have to say
I have to s- what-
concerning the submission made, that before you filed an application for
Yeah.
condonation of delay,
Yeah,
the first required step is that you have to take the leave of this court to file an appeal.
Your Lordship,
But you're saying that let the condonation be decided first and then you will file an application or what?
of course, because it has not yet been admitted, the appeal has not yet been admitted, so
So before
If your lordship
you
give me
file,
time.
let's read the section again, 378(4).
My lords. May I read it, if my lords have it?
Let him read.
My lords.
378(4). Please read.
in such an order of acquittal is passed in a case of institution upon a complaint, and the High Court, on an application made to it by the complainant, in this behalf, grant special leave to the appeal for the order of acquittal. The complainant may present such an appeal to the High Court.
So you have to take steps for filing an application or for filing an appeal, isn't it?
Yes, Your Lordship.
Then read 5. Read 5, subsection 5.
No obligation under subsection 4 for the grant of special leave to appeal for an order of acquittal shall be entertained by the High Court of the expiration of six
Okay.
months. Yeah.
So now you have expired 6 months.
Yes, Your
So
Lordship.
in your IA, is it, but in your appeal application, have you mentioned? So now this condonation of delay should
They
be
don't-
in the delay for filing an application.
Yes, Your Lordship.
So is there an application?
There is no application seeking leave, my lords. That's what I'm submitting to your lordships.
Yes, that is on our part, our fault. There might be a
So
default.
you,
Yeah.
you make an application.
Yes.
Okay, and then you're going to seek for condonation of delay for filing the application
Yes, Your Lordship.
beyond the period that is prescribed, that is how many days? 60 days?
60 days, please.
Yes, Your Lordship.
So then, after the application is decided, no, after the condonation of delay is decided concerning the application, then the application will have to be considered. Isn't it?
Yes, Your
I
Lordship.
think those are the steps that are required to be taken. So, you have directly made an application for condonation of delay in filing the appeal when there is no application. I think
Yes, Your Lordship.
that's,
That is correct, yes.
so What do we do?
If your lordship may allow me to file an
What are
application
steps?
for the special leave petition.
Well, if I may interject, well, that would not be permissible in this appeal. They would first have to withdraw this appeal, Millets, seek an independent application, special leave under subsection 4.
Because
With
you
the
have already
request of-
filed an appeal, yes.
That
So
cannot be
I
permissible.
think in the instant case, it would be more appropriate if you withdrew
Yes,
the
your lordship.
instant IA along with the criminal appeal, then file afresh,
Yeah.
taking the correct steps, isn't it? That is, you are going to file an IA again, but in your IA, it will be the condonation of delay for filing a delayed application
Yes, your
to
lordship.
allow you to file for permission to file an appeal against the acquittal, isn't it? So I think we can dispose of the matters by simply mentioning that you have prayed
For withdrawal.
for withdrawal,
Yeah.
isn't it?
Yes,
Yes.
your lordship.
Heard Mr.
David Malsomkima.
So and so, David Malsomkima, learned counsel for the applicant, along with Mr. Yes, Mr. K. Paul. is it?
Millets, K. Paul.
K. Paul, learned. You're a senior counsel? Okay,
Well-
assisted by Mr.
J.H. Raman Moya.
Okay, J.H. Ramne Moya. The learned counsel, senior counsel submits that the instant IA is not maintainable since the provisions under section 378 within brackets 4 and 378, section 378 within brackets 5 of the CRPC has not been followed. He submits that as per section 378 within brackets 4 of the CRPC, an application is to be made seeking the permission of this court to file an appeal against the acquittal of the
Respondent, Millets.
you're the respondent?
No, the
Against-
respondent.
Against the acquittal
Yeah,
of the
applicant.
respondent. Having heard the submissions made by the learned counsel, before that, the learned counsel for the applicant / appellant submits that he may be allowed to withdraw the instant IA along with the criminal appeal by admitting that the necessary procedure / steps provided under 378 within brackets 4 of and 378 within brackets 5 of the CRPC have not been followed in the instant case. And he prayed that he may be allowed to withdraw the instant IA along with the criminal appeal for taking necessary steps if so advised, and that he may be allowed to file afresh. For taking necessary steps and to file afresh if so advised. Okay. Having heard the submissions made by the learned counsels for both the parties, this court find it fit to allow the applicant / appellant to withdraw the instant IA within brackets criminal number 35 of 2023 and in connection with criminal appeal number 30 of 2023 and to file afresh if so advised. Accordingly, criminal appeal number, IA number 35 of 2023, along with the connected criminal appeal number 30 of 2023 stands disposed of on withdrawal. Yes.
Obliged.
Hearing list, part 2, item number 6.
Yes, disposed. After the ensuing vacation.
Item 9,
Same order.
12,
On behalf of her senior. No, appears, learned counsel, your name is here.
Yes,
okay?
madam.
Appears for the petitioner, while none appeared for the respondents. In view of the above, list after the ensuing vacation.
item 13,
Yes, none appeared for the parties list.